to be producer, is it?
I love what paint chips can do inside and outside the kitchen with an oversized mushroom.
George packed a bag by the light of the moon, said, "Germ, baby, I'll be leaving real soon." He cried by the courthouse, yelling at the sky, but George just waved and said goodbye. Oh, George left Germ, yeah, she hit the road. No more drama, no more overload. He's got violence, she's got freedom tonight. George left Germ and she's feeling alright. Surf guitar, George left Germ, goodbye.
I love what paint chips can do inside and outside the kitchen with an oversized mushroom.
George packed a bag by the light of the moon, said, "Germ, baby, I'll be leaving real soon." He cried by the courthouse, yelling at the sky, but George just waved and said goodbye. Oh, George left Germ, yeah, she hit the road. No more drama, no more overload. He's got violence, she's got freedom tonight. George left Germ and she's feeling alright. Surf guitar, George left Germ, goodbye.
All right. How's everybody doing today? We are here. We're talking a little bit about our good friends, Jeremy Hales and Megan Fox and that umbrella guy and a few other people in developing litigation-related news to the Hales versus Preston and Luthmann case in the Northern District of Florida, Gainesville Division. And with me today on Luthmann Live, I have the world-famous Chicago reporter, Mr. Michael Volpe. How you doing today, Mike?
I'm doing pretty well. So I don't know how long ago it was, but a week or a week and a half ago, Megan and Tug spent, actually, they split it up. We're only going to talk about one 25-minute block. But I wrote an article about how Judge Groeb, I think is the proper way to pronounce him, teaming up with his clerk, Candace Thomas, and Randall Shochet, how they falsely and in a misleading way found that Bruce Matzkin was unlawfully practicing law. And these two guys, they analyzed it, and I'm using the word analyze loosely. And basically what happened is I went down a rabbit hole and I watched too much of it. And I felt like if I didn't do something with it, I would have just been a waste of my life. So what you and I are going to do first is watch the 25 minutes and comment on it sporadically. So hopefully you've got the video up. So this is from about a week to a week and a half ago. I don't think that's the video.
That's not it. Wait, hold on.
This is going to be Megan and Tug.
Because the more we dig into this story,
hold on. Let's put it to the beginning. You ready?
It has to do with her.
Set it up, Mike. I'm going to set it up.
I didn't catch it right at the beginning. They've got my article up, but they're talking about something else. And what they're specifically talking about isn't important, but the tenor of the subject is important. And I'll explain that. But go ahead.
Hit play and make it happen.
Yeah.
We are finding out that that Jeannie is not innocent in this, and she's not just the innocent victim. And in fact, Fleesa has been, we've witnessed now 2 or 3 phone calls to the police where she claims that the neighbor did something to Jeannie that he did not do. And all 3 times the cops have been like, yeah, nothing we can do here. There was no violation. And we got Lisa on camera lying to police, saying that this guy did something that the victim then says he didn't do.
And then talking the victim into saying, well, yeah, don't you remember him? Oh, yeah. Mm-hmm, yeah.
And telling on herself with self-recorded videos of her laughing and instigating and screaming at the neighbor.
Okay, can you pause it?
Yeah. Do it.
I don't know what happened there, but they are hyper-analyzing Lisa's private life, going through police records. So they seem to think that what happened to you in your private life, if it reaches a police report, it reaches court, that's fair game. Keep that in mind.
Oh, what did I just do?
Somebody's ADA status. You called him what now? Crazy? No way. Can't do that. It's illegal. So let's see. Here we go. The result is a multi-front attack on Massachusetts lawyer Bruce Matzkin's professional livelihood and reputation. The whole thing started when Bruce Matzkin and attorney sent 4 emails starting in September 2025 to Candace Thomas, the clerk for Florida Judge Robert Groeb. This was regarding one of several legal matters involving Michelle Preston and YouTuber Jeremy Hales. Hales decided that Preston, along with her daughter, could be pawns for protracted. You know what's crazy about this? This is actually about Preston's lawsuit. So when he's like, oh, you know, it's for, they could be pawns and a protracted storyline in which he turned their lives upside down for YouTube content. At the center of the scheme were several frivolous lawsuits at the state and federal level. Oh, wait.
They were hers.
Yeah. See, he leaves out the most important portion of that.
The frivolous lawsuits were hers.
Can you pause it?
Yeah. Sure.
All right. This is her lawsuit that we're talking about, but are they denying that Jeremy Hales has filed a series of frivolous lawsuits? He recruited Michelle's daughter's biological aunt to file to get custody back. It was dismissed 4 days after he filed it. Does anyone think Fed 2 is legitimate? He filed against the prosecutor, Dan Owen, for not prosecuting Michelle. He filed a protective order in Ohio, even though they live in Florida. And these two are like, he's so misleading because this particular, and I didn't say that he filed it. I didn't say anything, but he's so misleading because this had to do with Michelle filed. And that's true. Maybe I should have added the one sentence, but listen to how long they go on and on about it. Go ahead.
Holy shit.
My God.
What a terrible
What a
fucking
piece of
actually,
shit.
you know, it's not
so misleading.
Yeah, well, it's because he's not
Mike, you're a piece of shit.
Again, he's doing for hire bullshit content. He knows it's misleading. That's the whole point in that. I mean, if you're telling people that you're offering articles for a certain fee, you know, per thing, well, I mean, there has to be a hitch to it. And I guess this is it. Man, how does it feel, I wonder, to fucking just not have any conscience at all?
Mike, you have no conscience.
It's got to be a weird feeling, you know, not to worry about harm that you do or anything else. Because these people, they just lie. Man, I mean, it's not misleading. That's not misinformation. That's disinformation right there.
Wow.
God. So Matzkin represented pro bono. I'm confused by pro bono, though. You know, Preston in one federal lawsuit, but these emails were sent about a separate state lawsuit playing out of Levy County, Florida. Matzkin noticed several potential errors, including that Thomas had falsely entered a default despite Preston filing her answer. Oh, man. Miss Thompson, this is the thing about that. Now, you notice we're only getting pieces of emails, by the way. Are we going to get all?
Whoa. Go back. Hold the phone. Wait, go back.
Where?
Scroll back up.
How far?
Matzkin noticed several potential errors, included.
Yeah,
Get your fucking grammar right.
Including
that Thomas had falsely entered a default despite Preston filing her answer. A default in which case?
I think he's.
All right, can you pause it?
He's supposed to be talking.
All right, so now they caught a spelling error. I fixed that. Now they're analyzing Bruce's email, and they're going to try to prove that Bruce was wrong, except it completely misrepresents the article. It doesn't matter whether Bruce was right or wrong. And why Why would I put all 4 emails in? I described the 4 emails. Can you imagine if I had all of the emails clogging up the article? I said he believed that there were legal mistakes and he was making arguments. Everyone reading it understands that the emails are similar to this, that he's making a legal argument. And now Megan is going to spend 3 minutes trying to figure out if Bruce was right. And by the way, the default was removed eventually. But listen and watch what happens as she tries to prove that Bruce was wrong. Go ahead.
Talking about the trespass case? I'm confused.
Oh, the trespass case. No, false. She did not she did not file an answer. She filed something that was completely inappropriate. She filed like a motion for maybe a motion to dismiss or something. It wasn't the right answer. She filed a completely wrong document.
Well, and Bruce here too. He's also, again, he is operating as an attorney. Look at what he's writing here. Why would a default be entered in the case even though Ms. Preston filed an answer prior to the entry of default? Rule blah, blah, blah states blah. So when you look through this, I mean, would you get the impression that this person is their lawyer?
All right. Can you pause it?
Paused.
Yeah. What is your understanding of when someone is practicing law?
So there are 2 things that constitute the practice of law. There are 3 things that constitute the practice of law. One is the signing of legal documents and the filing of those documents, right? So when you sign legal documents and you file those documents with an authority, either with the clerk, the county clerk, like if it's a real estate deed or a conveyance, or if you are a litigant in a case and you file it with the clerk of the court. The other is representing yourself as an attorney at law before a tribunal, right? So if you go to court and you say, I'm a lawyer, you dress in a suit and you start, tell everybody in the hallway, give me $500 and I'll represent you in your traffic case. And you do that, that's the unauthorized practice of law. So that's the level of what it has to be. It has to be an actual provable event when you cross a threshold, and that threshold being the signing and filing of documents or the actual appearance and representation as an attorney before a tribunal. Anything before that is by Supreme Court precedent is excludable because of the great power that the First Amendment has, the power that we have to give opinions and the power that we have to talk about things. We can give opinions that smack close to legal opinions, but are still protected by the First Amendment. Once you cross the threshold of giving an unequivocal legal opinion by engaging in that legal act, that's when it turns from speech into the practice of law.
All right. So but if you send an email to a clerk, isn't that the equivalent of filing something?
Well, let's see what happened. You sent something to the clerk, right? You didn't file it with the court, may have signed it electronically, but it hasn't been filed, number one. Number two, there are plenty of reasons why something can get sent to the clerk. You can send it to the clerk not for anything other than asking a question, like a person like you or me, a journalist might do. We might ask a question to the clerk of court about a procedural irregularity, an error on the docket. And this sounds like more like it was an error on the docket than anything else. And any citizen has a right to petition the court and petition the government for the redress of grievances. So if there's mistakes in the docket, if there's something that shouldn't be on a public record, every citizen has a right under the First Amendment and the 14th Amendment to petition the government for redress. So you have a right to send emails to the court to tell them that there's something wrong.
All right, now listen to their argument.
Let's hear it.
Lawyer? Like when you read that, Megan, is that person not their lawyer?
Yes, that's what it sounds like. And that's what the judge thought too, because he found him in violation of practicing without a license.
No. See, that's a conspiracy, Megan. Obviously, that doesn't make sense because no way. What really happened, Megan, is, obviously these 3 people worked together and they were all trying to take down poor Brucey Bruce, That's what really happened, Megan.
I'm going to go look at that docket and I'm going to go look at our files on the thumbnail because I am certain that what she filed, I remember this, and what she filed wasn't proper. It wasn't the thing she was supposed to file if she filed anything. But I have to I have to check this because I know something. I know he always lies. First of all, he never tells the truth about anything. So that can't be it.
Always lies, huh?
It's just crazy, like how it's not just filled with lies. You know, it's filled with some of the dumbest lies I've ever read. You know what I mean? God.
Yeah, I keep getting logged.
It's got to be a conspiracy, though.
Pissing me off.
Matzkin wasn't a lawyer on the case nor a party. The emails could have been ignored. But Thomas ignored. See, this is the thing. What this tells me is that Bruce has been writing in a lot of other cases, and I imagine other people have been, quote unquote, ignoring his emails, which we know that's what they said that they were.
Yeah, interesting. I don't present facts. And by the way, Megan never figured out what she filed wrong. And Megan, you've had a week. You claim other people lie. So was Bruce correct or are you correct? You claim Bruce always lied, that she didn't file properly, but he just accused Bruce of sending these kinds of emails in other cases with absolutely no evidence. Tug, do you have any evidence that Bruce makes a habit of sending emails to clerks and interjecting himself into cases? Do you have any evidence? Because if you don't, didn't you just present a lie? Go ahead, keep playing.
Well, I'm going to defend Megan because she's about as sharp as a spoon, and you know she's got her own problems. You know, she has to walk around with a helmet, a watermelon helmet, to make sure that her fragile little brain doesn't explode. So I wanted to be, but everybody clear about that. So we'll go back.
You know, that's what the Fed judge said they were ignoring.
Mm-hmm.
Which is insane because it allows this type of stuff. It allows this garbage to continue on. You know, they could have, but he put them on the record. Oh my God.
Jeez, where did we put Trespass 5? I see thumbnail, but I don't see Trespass 5. The hell did we put that?
It's called it's got a name like another case or something. I don't remember. It's got a weird name in there. It's been a minute. I haven't looked at it in a long time. So,
oh, is it Granger and Granger?
No, I don't remember what it's labeled as. I'm trying to remember.
Because Granger and Granger would be when they sued her. But isn't that the one she defaulted on?
The trespass.
Or was it trespass?
Megan's still trying to figure out how Bruce is wrong, folks.
Granger, the Granger case spins out of that. I'm trying to, like I said, it's been a minute since I've looked.
Oh, there it is. Lloyd RV lawsuit. Okay.
Now there you go. Lloyd RV. I knew it had like a weird, because when it started, you know, we named the file. We probably should name it.
You put Trespass 5 in quotation marks after it.
Okay.
Yeah.
But, you know, we named it when it first started too. So, you know, a lot of these names, they're kind of funny. I hate to lose them because they're funny when you go back. You're like, oh, yeah, I remember why we named it that way.
Now, voluntary dismissal. Okay, yeah, she dismissed it. I don't remember what the default was for.
I cannot remember how all this stuff comes together. I'd have to refamiliarize
I
myself.
don't either. I need to look at the actual docket and see what the order of stuff was. Okay, I'm sorry. I got distracted.
Right.
I will look at that later when we're not live on the air.
This is all the same argument she started like 3 minutes ago, where she was sure that whatever Bruce said was wrong. And after 3 minutes, she goes, I need to look at this when I'm not on the air. Okay, Megan, now you have time. Prove that Bruce Matzkin was wrong. I didn't even comment on the email itself. All I did was take a screenshot of the email so the audience gets a flavor of what he was doing. I didn't say it was right or wrong because it doesn't matter, because the unlawful practice of law that doesn't require you to be practicing it proficiently. You could be giving terrible advice and you could still be unlawfully practicing law. But you've had a week. Prove that Bruce is wrong or admit that you had no idea what you were talking about. All right. Keep playing it.
All right.
I'm sorry. Continue with this.
Oh, it's all good.
Really fascinating piece of journalism that you found on the internet.
What's amazing here is the other email. Why didn't we include the other emails? Why didn't we just get a piece of it? If you wanted to be, if you wanted to truly cover this and show how he did nothing wrong, why not enter all the emails and truly show that? You would think, again, if he's, because it's not, this clip here is not indicative of what he was doing. What was indicative of what he was doing is he was also going after the people involved in a lawsuit. He wasn't just talking about, there's this or that. He was 100% talking about how Bruce here, he was again practicing law without a license. He got himself in trouble.
Can you pause it?
God.
He spent a long time criticizing me for not releasing all 4 emails. Do you have any idea based on what he just said, what are in the other 3 emails?
No idea what he's talking about. What's he talking about?
He is convinced that the other emails will really shine a light on how to, and folks, I just took the first email that I found online. I wasn't scouring Bruce's emails to try to find the one that painted him in the best light. All right. He just spent 3 minutes. He has no idea what are in the emails. He has no idea why releasing the other emails has any kind of gives you any kind of insight. He doesn't even know what's in the other emails. And by the way, if he's so worked up about it, you can go to the docket and release the other emails yourself and read them online. But they didn't choose to do that. They just chose to criticize me for not releasing all 4 emails. So far, the criticism is that I should have said that this lawsuit was filed by Michelle, that I misspelled including, and that I should have released all 4 emails. Go ahead.
Right.
I just love how we leave out. That's so weird. Anyway, those entries were enough to set off Randall Shochet, Jeremy Hales' unscrupulous attorney. Hales' strategy since he started torturing Preston has been to file anything and everything, then create drama from that filing. Oh my God, what a way to spin that, right? Man, I thought terrible. You notice he didn't quote Polymop. Fat Boy did in his newer filings, by the way. Mm-hmm. He actually threw in Polymop.
Mm-hmm. Really?
Did I? Paint Chips did?
Yes.
Oh, what an idiot.
It's in this.
What an idiot.
Oh, my God. It looks like such idiots when they do that.
All right. Can you pause it?
Shochet.
Why did you put Polymop into a legal filing, and why doesn't that make you an idiot?
It was devised by a brilliant attorney named Bruce Matzkin, who coined the phrase. Mm-hmm. That's number one. And it is a term that actually it's a matter of fact. It helps to organize the factual occurrence that we see related to the litigation that's engaged in by Jeremy Hales and his attorney, Randy Shochet. There's a pattern of behavior when you have something that are patterns, that are common schemes or plan, that are a lack of mistake or negligence, that is intentional activity. That's always something that is a core of evidentiary questions and evidentiary searching. Mm-hmm. So when you want to state something in your pleadings or in your motions that you're going to pursue an evidentiary theory, that's how you do it. You define what it is you're going to show with the facts, and then you prove it with the facts. Well, Polymop is an organization of the facts for an evidentiary purposes on the basis that I just said. It's going to show a common scheme or plan. It's going to show conspiracy. It's going to show intent. It's going to show identity. It's going to show lack of mistake or negligence. It's going to show transactions and series of transactions and occurrences. It's going to show a lot of different things. It's not going to be good for them once everything is shown.
These folks who cover every single just about filing in every single one of these cases are sitting there with a straight face and saying, these things aren't filed just so we can talk about them. TUG doesn't do anything but this case. Anything filed just about in any case related to Hales, TUG does a YouTube show on it. Other people do YouTube shows on it, and they are speaking with a straight face as if suggesting that things are filed strictly for YouTube content is crazy talk.
Yep.
Go ahead.
You want to go forward? Okay.
Yeah.
Who previously lost his dental license due to fraud has a block. Wait, now they're just his dental license. Dude. I thought the whole. Oh my God, that is so bad. His dental license.
Yeah, because they had to go back. Well, he was a dentist.
Well, yeah, but remember the whole thing was supposed to be not about a dental license because the whole point in bringing up the dental license thing was for them to try to say, oh, he's committed fraud on the courts, because he couldn't have disclosed this and all kinds of dumb shit. You remember that's the whole point in that. By itself, it means nothing. It doesn't.
Can you pause it?
Doesn't strengthen. It just makes it sound.
Does it mean nothing that he lost his dental license due to
Well,
fraud?
it means a lot because he was in Missouri practicing dentistry, and the reason why he lost his license is the important part, because he wasn't just very bad as a dentist and breaking people's teeth and causing them infections. That's not why they took his dental license away, because he wasn't skilled as a dentist. They took his license away for 5 reasons, called FRAUD, fraud. He's a fraudster.
Right.
He was doing billing fraud, and then they caught him doing billing fraud. They suspended him from the practice of dentistry, and he continued his fraud by continuing to do procedures and continuing to bill under somebody else's license. So the guy is a fraudster, and so when you have the Arkansas bar, which detailed this when he went to Arkansas to try to get admitted under the Arkansas bar, they said, buddy, you're a fraudster. We can't trust you as a lawyer. And so what did he do? He lost the Arkansas bar. He went away. 5 years later, he comes back and he goes to Florida, and Florida's like, oh, come on down, boy. So
they gave him. Does it sound like TUG and Megan know the details of what happened with his dental license?
Well, I'm not sure if they know how to read. They claim that they do.
Does it sound like they know the details of what happened with his dental license?
Maybe. I don't know what's going on in their minds, but probably.
I don't think it doesn't sound like they know the details. They may know the details, but they don't sound like they know the details. So they've been doing this story for a while, and they can't verbalize the details of what happened with his dental license. So, you're questioning my professionalism, but you can't explain the details of what happened with his dental license. Yeah, even if he hadn't tried to get a law license under dubious circumstances, the fact is it's been determined that he committed fraud. That's important. Second point, how many times did they point out that you went to jail?
I don't know.
A lot.
I like to say that.
A lot. How come? Oh, it's really important. Everybody knows you went to jail, but it's not important that anybody knows that Randall Shochet committed fraud. How does that work?
I like the tag that I'm a felon, like our great president. It's like my street cred. That's what it is. I'll show my prison tats one day. That's what.
Right. You, Trump, and Nelson Mandela. All right, keep playing it.
That's right.
More clown carious. It sounds almost like Miss Stark's new emails about money and aliens. That I liked that one. I thought that her stuff is so crazy, man. I'm blocking more of you. Anyway, Shochet willingly filing flimsy arguments which are used for YouTube content. Shochet followed Thomas's lead and filed a motion to strike Matzkin's emails while accusing him of unlawfully practicing law. That is so dumb. The judge didn't make the decision on it. No, gotta blame it on the assistant. Isn't that something? Now, Shochet didn't respond to an email for comment, while the Levy County courts issued this statement on Thomas's behalf. In response to your email sent to Candace Thomas, judges speak through their filings, and it would not be appropriate to offer additional commentary outside of that context. Yeah, you can imagine what kind of email was written there too.
Oh, I'm sure it was awful.
Yeah, it was scumbaggery.
All right, pause it.
I've seen a few of these examples.
And then they go on to say that my emails suck, but they don't actually say what sucks about them. Can you get that down? Since they're so upset about what the email that I filed, but can we take a look at the email that I filed?
Yeah, what do you want?
Hold on. Hopefully I can figure this out. No. Am I able to
I guess I'm waiting for you to do it. Put it in there, and we'll put it up.
All right. So
take all the control.
Here we go. This is the email, and I'm assuming you see that as well.
Everybody sees it, Michael.
All right. So it's easier for me to read it. It's Michael Volpe again with this site. I'm going to be doing a story on the emails that Bruce Matzkin sent to you, which led to an unauthorized practice of law against him by Judge Groeb. This was case number and the case number. Why did you put the emails Bruce Matzkin sent to you on the docket? Why didn't you remove the default? Ms. Preston responded before you put on the default. This seems like a setup because that leads to Randall Shochet filing, for unauthorized practice of law in a case which was stayed against someone who is not even party to the case. Your action started the ball rolling on a legal absurdity. Were you coordinating with Mr. Shochet? And the response that they read is the response that you see. And was that an outrageous email?
Outrageous.
Yeah, so they made comment on an email they never saw and just presume that. And by the way, do you normally get responses from people if you send a snarky email that just makes fun of them and doesn't really ask any questions? Do you normally get responses that way?
No, but you send more than I do, Mike. And I send a lot of it, but you're like A+ in that. You never get
right, but they're acting like I must have sent some like crappy email, and that's how I got them to respond. That's not how it works at all. Get it back up. Let's keep listening.
It's not asking for your God. You know what's really sad about him, that he makes Taylor Lorenz look like a scrupulous character.
Taylor Lorenz.
That's the craziest.
That's
thing.
True.
He does, man. Because at least Taylor Lorenz will, like she'll go off on 95% opinion piece, but she'll work in some thing that has it's totally truthful, and then again,
can you pause it?
We'll just add in.
They just got done speaking their opinion about an email they didn't see, and then have the gall to compare me to Taylor Lorenz by saying, well, all he does is say opinion. He doesn't throw in any facts. All right. They didn't have any facts. They had no idea what my email said, but decided to chime in and insult me anyway, and then have the chutzpah to go, he's like Taylor Lorenz. All right, go ahead. Keep playing.
Nope, what did I just do? I hit the wrong button. We're over here somewhere. All right.
That's the craziest.
That's
thing.
True.
He does, man. Because at least Taylor Lorenz will, like she'll go off on 95% opinion piece, but she'll work in some thing that has it's totally truthful, and then again, like we'll just add in some random thing. Him, God, he just makes some shit up with it. So Shochet made a flimsy argument. Matzkin never claimed to be represented. That's not how you don't claim to represent the person. That's not how. Oh my God. So his thing is, since Matzkin didn't claim to be representing her, he couldn't be unlawfully practicing. That is the dumbest.
Yeah, that's not true.
That is so dumb. I mean, that's what he's trying to argue there, which is, I'm not surprised by, actually, to be honest. God, Megan, you know you uplifted this idiot for way too long. You know that.
All right, pause it. They're about to talk about
Listen,
how me and her together. Can you pause it?
Yeah.
He says that my argument is bad. Does he, besides making fun of me, does he present any evidence of my argument being bad? Is there a law?
The first thing he says, you don't present any facts.
Mhm.
But all of this that is here, you write in a very straightforward, factual way. You present fact and fact and fact and fact. So the entire, the presentation to this point has been facts. And then he comes and says he presents no facts. So that's a little bit crazy. Then he doesn't like where you're going with the facts, how you're positioning the facts and the implications of those facts. And therefore he says that it's all opinion and your opinion's terrible. But you're 100% right. He doesn't present counterfacts that might make your factual presentation correct.
If there's case law or a law that says that if you present an argument to a clerk, you are practicing law, then he should present that, especially if it's Florida case law. But he doesn't do that. He just says, you're stupid, you're wrong, without saying how I'm stupid and wrong. Now, I may be wrong, but how far into I think it's 25 minutes. How far into the 25 minutes are we?
We're about 13 something in.
I may be wrong, but they're going to keep my article up there, but they're not actually going to talk about it anymore. And now Megan's going to go into a long diatribe about how I'm a terrible person.
Okay.
All right, let's go.
Let's go play.
The tattoo on my neck I cover up that says no regrets?
Yeah.
It's the biggest regret of my life. I do have a few, and this is one of them. I am too sympathetic to morons, and I believed at the time that he was that he had the same types of goals that I did. I knew that he wasn't real smart, but to me, not being smart is not. It's not
You also thought he was a friend.
It's not a character flaw, right? Not being real smart is not a character flaw.
But you also
You're
thought
either
he was a
born that
friend,
way
though,
or you're not.
I mean, that's like if you think somebody's a friend, you tried to help them out too.
Yeah, I mean, we didn't spend a whole lot of social time together or anything, but I mean, I never thought that he hated me. I never thought.
Can you pause it? I didn't hate her. I don't hate her now. I don't know what she's talking about. I first met her in 2014. I was working with a website called rebelpundit.com. It's unfortunately no longer online. Jeremy Siegel was a great reporter, ran it. And she reached out to us because I don't remember the other guy's name, but they were doing a story about how I think it was Orland Park, but it was a suburb south of Chicago. I think she was living in at the time, was allowing porn in an area where kids like congregate.
Porn.
And she's trying. She had done a lot of stories on it. They were retaliating against her, the library and other powerful people in Orland Park. She's trying to get more publicity. I did at least one story. I may have done more, but definitely one story. That's how we met. In 2021, I got this Zoom conference of a bunch of corrupt guardian ad litem. It was my plan to try to recruit Megan. The initial start of that plan was to just tag her on Twitter while I released the video on YouTube. And she called me and she said, "Hey, friend." And she wanted to know about the YouTube video. And she chose to cover it. And we did it for about a year. So all of this, he's stupid. And, if I was stupid, why would you proactively engage with me? And if I was stupid, you told no one. I've sent this email to Megan. Bring anyone forward who knows both of us, who will say, yeah, Megan in 2021 thought you were stupid. You didn't tell anyone that until now. All right. Let's keep going. And then she's going to
Liked me,
claim.
or I didn't think he hated me
Does it
like that.
shock you now to see how he acts with all that? Does it ever shock you? You're like, oh man, what a
Yeah. No, I can't believe it. I can't believe it. Especially, maybe it's because I'm the kind of person that if I have a problem with somebody, unless something happens that forces me to talk about it, I won't. You know? So like this happened, I was forced to talk about it because he did terrible things like release text messages and try to, and just.
Can you pause it?
Yeah,
she's talking about, and can you get rid of it? I want to put something up. She's talking about the text messages that I released, that we went back and forth, and I think this will come up. And so let me read it. They, referring to, I think, the anti-Hales ecosystem, though at the time I didn't know that's what she was talking about. No, we work together. These people have been trying to take down my channel. Yes, they know. That's why Bruce contacted you. And then I said, regardless, we're talking about Mac Daddy. That's a story that she didn't cover that involved Bruce Matzkin. Again, you are showing me that you have no regard for me at all. These people are harassers, doxers, and defamers. They have been doing these things to me for months. And if you give them any legitimacy, then that tells me we are not friends. That was released on December 1st, 2025 or 2024. I didn't start covering the Hales case until January of 2025. And the reason I started covering the Hales case is because I was like, well, if we're not friends, then I'll cover the case that I didn't want to cover. Bruce started telling me about this case in the summer of 2024. I probably would have eventually covered it, but if Megan had left things alone, I wouldn't have. I was giving her deference, but she stopped being friends with me. And by the way, I think Dave is on here. He later said, I had no idea you knew Megan. I did want to talk about the Mac Daddy story. I wasn't going to bring this up. So she was completely wrong about all of it. Can you get it back up?
Sure. You got to put it back on the stage.
The last thing is the reason.
Put it back on the stage, Mike.
Put
it back on the stage. You pulled it from the stage.
What do you mean? No. Can you get the video?
The video.
He tried to call you a race, and you know the craziest thing about that.
Oh yeah, you wanted to make a point.
The reason I released the email is because she started saying I was betraying her, and I was like, I wasn't betraying you. You stopped being friends with me before I said one word about Jeremy Hales. All right, keep going.
All right, let's see.
By using a text he sent and saying that I did it.
Yeah, that was wild. You know, I mean, that's just, to me, it was amazing. You're covering something. He decides, hey, I can make this a payday. So he brings in a felon partner, and him and his felonious partner, they don't do any research. They want you to come on and argue the case where they've done no research and they've told you. You know, that way they can just act like a couple of douchebags, basically, and probably yell enough or whatever, say something pretty gross, and maybe get a nice YouTube clip out of it, right? And then they could be like, we owned her, you know, and make a few bucks off the antis. But you were like, nah, I don't want that. In fact, if you're gonna deal with it, I don't want anything to do with you.
So here they're saying that, hold on, here they're saying why we were trying to get Megan on, and that's just crazy and totally ridiculous. Am I right? To talk about the Hales case, am I right?
That's right.
All right, can you get rid of that?
What, the whole thing? Okay.
Yeah, I'm going to share something with folks.
Oh, Michael's sharing. I like this.
All right. So hopefully I got this right. And now I don't know what gave you the crazy idea that
Grudge Judge, it's so funny, it's so good. We got Judge Craig Thomas, one of the worst judges in America. We got him kicked off of one case already for showing his bias. And I mean, the appellate court just ruled that he did illegal things in the What the Hales case. What the Hales is a huge YouTuber, 700,000 subscribers. He's in a neighbor dispute. We're covering that neighbor dispute, but we're also covering now another neighbor dispute that Judge Thomas has ruled over as well. And so we're going over the hearings.
So you may have gotten the idea that she would come on and talk about it because she came on and talked about it.
She did.
Now,
that was our third show.
She was perfectly happy to discuss the Hales case with us when she thought the questions would be softer. But the minute she realized we may ask tough questions, that's when she said, I'd never come on. All right, can you get the video of Tug and Megan back on?
Mm-hmm.
There are a lot of people.
I warned him. I told him ahead of time, if you get into bed with these people, that's it. I'm done.
Yeah.
I will not know you anymore. And he thought that was just so terrible, just so awful. Who did I think I was telling him who he could talk to? It was like, you don't get it. If a friend tells you, hey, these people are trying to burn my life to the ground, so I would prefer it if you avoided having anything to do with them. And then not only does he not listen to me, but then he goes and gives them my emails and my text messages. What would you do?
Oh, yeah. I thought that was pretty jacked up. Actually, you know what? Getting to know these
people. Can you pause it?
Again, it just...
I didn't give the emails and text messages until I realized she was serious about stopping being my friend. That text message you guys saw when she said we're not friends anymore is December 1, 2024. I didn't realize she was serious until she had blocked blocked me on Twitter and removed nearly every video we did in 2021.
That's the thing that I take the most umbrage with. In that you did some good journalism, particularly in the Missouri family courts, and you helped out a lot of families, a lot of people the only way that they got any modicum of justice was because of the exposure that you brought to their cases. And in one fell swoop, because of a interpersonal spat, she turned her back on all those families. That's a disgrace. That's what I think is a total disgrace. Right.
And when it was on, and I don't remember what emails she's referring to that I shared, but I didn't share that many. But I didn't do anything until she said we're not friends anymore. If she had said nothing about me going on with Dave, and she's acting like that's correct. If a friend says don't go on with these people, that's ridiculous. For one journalist to tell another journalist don't do an interview is completely beyond the pale. And if Dave had tried to spin it from what we agreed to talk about to Hales, I would have stopped it. I would have gotten off the air, frankly. And then I would have apologized to her. But Dave didn't do that. She's spinning this, and that's partially why I released these emails and text messages, because she's just lying about what ended things and how it all materialized. All right, keep going.
What it shows is, like, again, I've done this. I did this with comics and some other stuff too, where I thought people wanted to change something like I did. I thought they had the same values, core principles that I did. And you would run into people that absolutely, so a lot of people, again, good people I'd run into, people like Yellow Flash, for example. But for every Yellow Flash out there that I would run into, I'd run into, 5 people that were just absolute douchebags. And, they would lie, and because they knew how much, they can make money and stuff. And they would burn you, you'd make them money, you'd help them out, and they repay you by trying to ruin your life. It's kind of amazing, I wasn't surprised by him, but I've
never had that happen to me before. That was the first time where it was like, oh, wow.
So this is what a piece of shit really looks like.
Yeah, like I've seen other people do it to other people, YouTubers and whatnot. but I had never had someone I knew personally try and someone I'd never harmed, that I'd always helped, that I went out of my way to help. I had never seen that happen before. It had never happened to me before. So yeah, it was
Well,
upsetting.
pause it.
It's an ugly learning lesson, is what.
She's spinning. All right. She decided, because I would go on Milltown's Best to talk about a completely different story, that this was reason enough to stop being friends. She removed all our videos.
Yeah.
I didn't even realize it for a month. And then I started covering the Hales case. And she's a bully. She's teaming up with a YouTuber to pick on people that she thinks won't fight back. I didn't change. I didn't team up with scummy YouTubers ever. She used to not. But this is all spin. And everything that happened with the Hales case was after she said, we're done being friends, because I wanted to go on Milltown's Best to talk about a story she didn't want to cover. She had been upset that I was working with Bruce. And I said, it has nothing to do with you. We don't mention the Hales case. I know what the Hales case is, but this is a separate story. She was already upset about it. I knew that it was going to blow up into something because, I decided to work with Bruce. But this is all spin that she's talking about. Nobody was betrayed. If anything, I was betrayed. She removed probably like 40 videos that we had done over a year. Because she got mad.
And hurt people's lives because of that. They're not videos of cats playing with yarn. These are videos about family court, about people's kids, about kids that and abuse and domestic violence and everything else. It's out of control. She's got at that point in my mind is when she stopped being a journalist, because any journalist understands there's a responsibility to the people that you cover, especially people in vulnerable situations. And to her to do that so cavalierly and brazenly, just because she had a spat with you, shows that she's not a journalist. That's what it shows me.
Right. And also she said, I'd call you. She never called me. After that text message, we didn't talk. All right, keep playing.
It is, you learn really crazy lessons I think online really brings out the worst in some people, I do. I think if you think people are bad in regular life, you meet some really awful, just awful behavior sometimes. It's not just awful, it's awful behavior. But I mean, you see there are some pretty bad actors out there. Like for example, I've gotten into the habit of really starting to look into, now again, I can't say that everyone I run into, like if I've looked into them a little bit, like that catches everything. But with people like Paint Chips, for example, like they're a good demonstration of why I try to look into people before I deal with them anymore. Because, you might think, oh, that person's that person seems okay. And then,
you want to pause it?
Burn your life to the ground.
Yes.
Well, you see,
they're not okay with what happened to you. You went to jail, but they are okay with committing fraud as a dentist.
Yeah. Well, it is what it is.
All right.
Don't worry. I got my pardon in. So when my pardon comes back from Trump, I'm going to have a party. I'm going to have a huge party.
All right. But they're going to have to eat it. They're very selective about what people's past are and are not important. All right, keep going.
All these people in the anti-circles that they talk about. I didn't know this about. Well, I never thought to look into this, And I mean, I understand that, although I don't really understand it where we've screamed about it this long. It's kind of hard to deny something when we're talking about it over and over. But I do get it. But I've gotten in the habit of looking into people. Anyway, so he didn't, there's your email there, or there's your answer there. Shochet made a flimsy argument. Matzkin never claimed to be representing, and emails to a clerk wouldn't constitute practicing law. Well, oh my God. Yes, apparently they weren't just random emails. He was trying to argue the case, the merits of it, and he was attacking the parties in the case. Again, if I read that, I would have thought that he was Lynette Preston's lawyer. I really would have thought that from reading anything that he brought
Can
up.
you pause
But
it?
He just proved that he's a moron.
If he was Lynette Preston's lawyer, wouldn't he have a more legitimate, if he was trying to act as Lynette Preston's lawyer, wouldn't he have a more official way to do this? Why?
Make a filing.
Right.
Yeah.
He says this, and maybe in the layman says it makes sense, but in the legal sense, you look up law, you look up case law, you look up maybe rules. That's how you show that something is or isn't like the way that you're describing it. This is just vibes. He's talking about vibes. Well, he sent an email. He represented himself as a lawyer. That's the unlawful practice of law. And the argument I made that they won't get into is what Shochet then claimed is, well, actually what he did was he ghost wrote some filings, motions, and other things, and they won't get to it. But when Scott Stark was deposed, he said, no, Bruce helped, but I read it. I made the final changes. I put my signature on them. They are mine. And Shochet misrepresented that. Now, they don't get to that part. But, if Shochet had just come with 4 emails, it probably wouldn't have been enough. So he throws in this other thing that's completely misrepresented. But keep going.
again, I guess none of that matters, right? Because that's not practicing law. This is the same dude, by the way, that told us that that men don't qualify under VAWA.
Right.
I can't get my protective order because, like I said,
Can you pause that? I never said that men don't qualify under VAWA. What I said is this guy is obviously misrepresenting himself and manipulating the law. Men do qualify under VAWA, but it's like 95% women. I said it's interesting that he used VAWA to get this protective order like he's a female
I'll say it.
Violence victim.
Like he's a bitch. Like he's the bitch that he is, Mike.
Hold on. 5 years ago, if Megan had found out that a dude was using VAWA, she would have written about it, whether or not it's legally allowed. This is a complete misrepresentation of what I said. Keep going.
I remember idiots that would say that kind of stuff, with men, and they're typically uncouth morons on Twitter that make comments like that. I've never ran into somebody like passing themselves off as a so-called journalist, that's like, I have done exposés on this system. And by the way, I don't understand how this man has misused the VAWA. Like, what? Anyway.
Crazy.
Can you pause it?
He dressed.
Is he actually saying that journalists never say any stupid shit ever? Yeah. That journalists from the most famous to the least famous, that you can't find statements on Twitter that are made fun of? Is he actually saying that?
I think he is. That's what he's trying to argue. Yeah.
Have you found journalists saying stupid shit online?
Well, didn't they just mention Taylor Lorenz a few minutes ago?
Yeah.
They killed themselves with their own argument. They're moronic people. These are very, very not smart, low IQ people. That's what we're dealing with here. They're very, very low IQ people.
All right. Let's keep playing.
Had secretly written motions in the case. Yeah, you mean that actually we know that Bruce, again, Lynette talked about him writing stuff. She talked about it. Holy God. She's got a big mouth. I mean, if Bruce wants to be mad at somebody, he should be mad at Lynette Preston. She sold you out, man.
Oh, yeah.
I'd be pissed. If I were him, I'd be pissed off at Lynette Preston, because she may, he's still, for some inexplicable but understandable because it's Bruce. He got butthurt about something, but for some inexplicable reason, Bruce is still in there, still messing around with this case. That's according to the Fats, by the way. Bruce is still around according to them. So isn't that fun times?
Fun times.
Yeah. So here's the filing.
I'm almost finished with an amazing project.
Oh my God.
That the garage studio is getting very, very full. Very full of mugshots. You're going to have to let me know if I have left any out here, but I want to show you this.
Okay. Sure.
I may have to do some more work on it, but you know, the garage studio is just full of felons and thieves and burglars and I don't know. I mean,
felons and thieves and burglars. Oh my.
Oh my.
Scam artists.
All right, check it out. What do you think?
All right, we don't need to watch the rest. So
we got Gaby.
Pause it.
We got 3.
Pause it.
Well, that's not even a mugshot. My mugshot, I'm going to
Guano.
tell you, but my mugshot's much better than that. That's just a coming out of court shot. I can give them real material. If you want real material.
Here, can you get rid of it? Can you get rid of that? So they stopped. They didn't finish. That's it. They don't talk about my story anymore, and they leave it off by saying, "Well, Bruce didn't secretly write these motions." Hold on, let me get something.
Oh, you want to finish? Okay.
Yeah, hold on. So they deliberately stopped in the middle. All right. Now, what I go to next is right here is this deposition. All right. And it says, okay, did you write the complaint in this case? Yeah, I had a person help me, but I made the final corrections and I signed it. So it's my complaint. All right. So that's very important because the person who wrote the complaint is saying it's my complaint. Now they didn't say that. They stopped it before. All they did, they tell their audience, well, you know, Michelle said he wrote it. Well, what Michelle said isn't important because Michelle didn't say anything under oath. But even more importantly, right here, here we go. From there, Shochet made 2 more misstatements. He suggested that Matzkin was served even though only an email was sent. Furthermore, he claimed that Judge Groeb could hear him on declaring Matzkin was an unlawfully practicing law. Only the Florida Supreme Court can make this determination, and there's the evidence. And conveniently, they stopped talking about it before they had to present that evidence to the court, or to their audience. Now, early on, they complained that I was misleading and unprofessional. Ooh. And here, they did not present the entire article, so they didn't have to deal with some of the evidence that I presented. What do you think of that? Is that a little hypocritical?
They're a bunch of hypocrites, Mike. That's exactly what it is. It's that's all they got. You know, all they can do is try to.
So you wanted to show your latest.
I wanted to show my latest. You know, we're talking about tramp stamps, so I wanted to let everybody know about the fact that, you know, they can give it out. I can give it out too, and that's what the basis of this lawsuit really is. The basis of the lawsuit that's still left, and there's only 2 people left. That's Michelle and me. And the basis that's left is that they can give it out to anybody they want, but they can't take it. And so I wanted to play the video that we started with, though. We have the video because people just got here. This is the new video for today. I haven't even launched it yet. You're seeing it here exclusively. So let's let everybody watch, and then we'll get into the second part of what we're going to talk about today.
I love what paint chips can do inside and outside the kitchen with an oversized mushroom.
George packed her bags by the light of the moon, said, "Germ, baby, I'll be leaving real soon." He cried by the courthouse, yelling at the sky, but George just waved and said goodbye. Oh, George left Germ, yeah, she hit the road. No more drama, no more overload. He's got violence, she's got freedom tonight. George left Germ and she's feeling all right. Surf guitar, George left Germ, goodbye.
Well, AI is taking over.
There's our buddy. AI is taking over. So, well, what we have here is, and thank you, Helen. It was a good tune. That's a really good one. And that's the modern, well, not the modern, but that's the latest news, current events of the soap opera that is What the Hales. But we're going to get into the legal. And I just filed and hit the courts yesterday the motion to dismiss. And what Mike, first thing you said to me when that happened was, Rich, you didn't respond to all the bad stuff that they said about you.
You responded to some of it, but you didn't. There were parts. So
and we'll put that up. Actually, we'll put that up, and we'll go through
So we're going to go through it. Rich will explain why he responded to some allegations and not to others, and I think he'll be able to explain it in a way that everyone can understand.
I think we'll be good with that. Let's put the video up. Actually, I'm going to take this down, and I have to do this screen right here for us, and then I have to put this up, and we're going to show the screen and share this one. Okay, here we go. Now, this is the third amended complaint. Okay, I'm actually going to go to the very top because that's the thing. The very top. This is what Jeremy filed last month, 4/27/26, the third amended complaint. Notice only two people left. There's Jeremy B. Hales. There's no more Elephant Shoe. Elephant Shoe was his company. He took away that Lanham Act, and there was some type of commercial issue with this. That's not here anymore. And all it is a third amended complaint for damages and injunctive relief. So Lynette Michelle Lacey, Alexis Preston, and Richard A. Luthmann Jr. So they're doing damages and injunctive relief. So the damages that they want, and I'll speak only for me because Michelle's case is a little bit different. But for me, they want to bring damages against me to the tune of about $370,000, and they want to bring injunctive relief to try to get me to stop my speech. And so we'll start with the claim itself because I was just on that. And everybody remember this as we go through this. You only get in law, you only get credit for what you sue for. So you could say this person did this, that, and the other thing, but you have to actually sue them for something. And the only count against me is this count number 2, violation of Florida sexual cyber harassment law, Florida statute 784.04.
And before you go on, this relates to your satire video where you have a photo of Jeremy Hales with a notorious speech by Andrew Tate, and then the body is someone else. I don't know if it's Tate. And that's the video. And
that's
then,
a still shot. That's a still shot from the video. So by their logic, if that video is revenge porn, this still picture right here is also falls under the ambit of the revenge porn statute. And so you can see by just this picture alone, there's nothing salacious, there's nothing private. That's the big thing. There's no expectation of privacy. Both of them are public figures that put themselves out there. They're open and subject to ridicule by the public. And there's nothing here that is inherently pornographic. Jeremy didn't send me the picture. Megan didn't send me that picture. They're not intimate pictures.
Their argument is you don't have a right to make fun of them without their permission.
Exactly. And they're using.
Well, what do you say to that argument?
Well, we're going to go back to the statute. You get what you it's this one. You get what you sue for. Violation of Florida's sexual cyber harassment law. They can complain all day that I made them feel bad, right? But they're not going to get any relief under the Florida sexual cyber harassment law. Okay? And here's what they said. And everybody, if any of these are false, then they lose. This is how this works, right? That's how the law works. Defendant Luthmann published a sexually explicit image of plaintiff. Did I do that?
No.
Can you tell me within the bounds of that picture that I just showed that it was sexually explicit?
No.
Okay. In 2025, Luthmann posted a video online depicting plaintiff as engaging in oral sex with a journalist. Did I ever show a picture of Jeremy Hales engaging in oral sex with anybody?
No.
Is Megan Fox clearly a journalist?
Yeah.
I don't think so. That's a question. See?
Okay.
So oral sex with a journalist. It could be any journalist. He doesn't identify the journalist. It could be Don Lemon for all we know. Jeremy Hales could have been having sex with Don Lemon in a picture. The images also contain and convey the personal identification information of plaintiff.
Meaning his face.
Yeah, wait a
His
second.
face.
Wait. So this is personal identification information.
Right. They're
This right
saying
here.
that you don't have a right to use his photo. That even though he's all over the place online, you don't have a right to use his photo. Meghan doesn't have a right to use his photo. And by the way, these are the same people who complained about Michelle's lawsuit about using her name, image, and likeness. Now claiming you don't have a right to use their likeness. How is that?
Now there's something under the law called personally identifiable information, right? That is a term of art. What that refers to is things that aren't publicly available that you can use to identify somebody, like a social security number, like bank account numbers, other things like that wouldn't be readily ascertainable. Right. You can go to the white pages of the internet and find somebody's address. You go to the white page of the internet, find their email in a lot of cases. Those aren't personally identifiable information. If you're a public figure, right, or even a quasi-public figure, you can go to the internet and people can find your face. You don't have a reasonable expectation in your own face if you inject yourself out there, and it's findable on the internet. So there's a lot of problems with that sentence, okay? Images conveyed personal identification information through plaintiff's photograph. No, this is actually false as a matter of law. You cannot convey through their photograph personal identification information. I think what he's trying to argue is that I'm conveying his name, image, and likeness, NIL. So I'm conveying his likeness. But since he's a public figure, I'm allowed to. It's like saying that that President Trump could sue people because they put his picture in the newspaper. No, that's not how it works. If you're a public figure, your name, image, and likeness is kind of owned by the public when there's a newsworthy event. Plaintiffs was specifically identified by name in the URL and content where the images were public. Yes, that's true. That's very true. Why? Because it was satire. It was related to newsworthy events, and we were making a critique. Plaintiff's physical attributes were readily identifiable in the posted image. That's fine. Yes, we saw his face. He's complaining that we saw his face. Right. The image video was published to an internet website. Sure, it was posted to many internet websites in the United States and other places. The video was published at this address at Substack, right? Plaintiff did not consent to the publication of the image. Plaintiff doesn't have to consent to the publication of the image, right? Plaintiff never consented to Luthmann publishing any images of plaintiff. These aren't private images. They're public images. There's no reasonable expectation of privacy. Then Jeremy says, plaintiff did not authorize, approve, or give permission for the publication of the images. He doesn't have to. Not when you're a public figure. And here's the good one, Mike. Explain this one. There was no legitimate purpose for publishing the image.
Right. He's making a like a subjective argument. There's no. You were making satire, and you were basically saying that Meghan. Not basically. You were saying Meghan is Jeremy's media bitch, and so that's the reason that you did it. But you could have like a weaker like reason for it than that, and it's still fine. You could do it just to insult him. In fact, you have a scene from the People versus Larry Flint where we talk.
We're gonna play that in a second, and I'll remind everybody there was a case with Bill Maher and President Trump a few years ago, and Bill Maher insinuated that Donald Trump's orange hair came from the fact that his mother had sex with a baboon, and Trump sued him, and the case got dismissed because you can insult people, especially public figures. You have every right to your opinion. So they just go this litany. This is what's called butthurt by Jeremy Hales. No legitimate purpose for publishing the image. They were posted to harass and defame. No legitimate journalistic educational purpose. Yet he does this to his neighbors every day of the week. Right. He does this. He does. This is what he says. Rules for thee, but not for me.
The same guy who films into Michelle and John's property multiple times per week, talks about them nonstop, thinks if you talk about him, if you use a photo of him without his permission, oh my God, I should sue. This is, you can dish it out, but you can't take it.
Yeah. So that's what we have here. And you know, when we go to this claim, you're only going to get credit for what you can prove. Now, and here's the best part. We're going to play the Larry Flint clip next to remind everybody what's going on. Defendant Luthmann intended to cause substantial emotional distress to plaintiff. You know, that's what the rule in Hustler Magazine versus Falwell says. It's that it doesn't matter whether it causes emotional distress or not. If you're a public figure, you know, satire is satire. Too bad, so sad. You cannot recover it in a court of law because it would destroy the First Amendment. Then they talk about Luthmann's intent to cause substantial emotional distress, evidenced by the context of the publication. Well, my context was critique. I'm not trying to cause emotional distress. I'm trying to raise issues. And then here we go. Prior to publishing the image, defendant had sent emails making false accusations that plaintiff was anti-Semitic and comparing plaintiff to advocates of eugenics and mass murder. The publication is designed to humiliate and distress plaintiff. Well, this is true. I did send questions about his anti-Semitism to rabbis and to the media. But what does that have to do with cyber-stalking? Advocates of eugenics, what does that have to do with cyber-stalking? It's a very thin statute. He didn't sue me for defamation, notice people, because he doesn't have a defamation claim. Didn't sue me for slander, didn't sue me for libel. And then he goes and he says, there's a Facebook page called What the Hales, which appears to be an official Facebook page where fans comment and their surprised supporters find out nothing more than a hate group. And they're saying that I posted the story in this hate group, and they put the hate group. And then they talk about Florida, harm, everything else. Now, the best part about this here, we'll keep on going. He talks about all the harm that he caused. And this is where he loses too. Subject to harassment, fear, extreme embarrassment, professional opportunities lost, strain on his personal relationships. That might be true because George is gone. We don't know. Encountered prolonged expense and inconvenience. Plaintiff's total damages amount to $370,000. He doesn't detail how we get to that number. Did he rub a crystal ball to get to that number? That's what we have. That's the problem that we have.
They did the same thing happen in Fed 2, where the judge said, well, you brought up this number. However, when that happens, you have to show your work. So he's just picking numbers out of the sky again. And
then what he has here in the 2 points here that kills him is here against the defendant Luthmann, he's asking for a preliminary permanent injunction, right? Prohibiting from posting otherwise and destroying all copies of sexually explicit images in Luthmann's possession. I'll do that. I have no sexually explicit images of Jeremy Hales or Megan Fox or anybody else related to the Hales ecosystem in my possession. I do not have any. This is not sexually explicit images, so he can't get that relief. And even if the court thought that I had one, they couldn't grant that relief because they can't preliminary enjoin speech, right? That's the first amendment. The second part, an amount over $370,000 or $5,000, whichever is greater, right? So the amount of statutory damages is $5,000 under the statute. So he doesn't talk about what the amount is. So he has a $75,000 threshold. Right, that he needs to prove. He needs to say not that it's 5 or 10,000. They ask that there's actual damages, or there are enough times in the statutory amount 5,000 that would warrant over the 75,000 for diversity jurisdiction. He's got a problem there. There's no diversity jurisdiction potentially, and then he wants attorney's fees. This is what Randy, right? So and they want interest. So this is what they asked for. This is what they asked for in this case, and it's a joke. And so I'm going to show everybody real quick what we're up against, and then we'll go to my claim here. So let's put this. Let us present this. I'll take this down, and then we're going to present this screen we have, and that is the People versus Larry Flint. Okay, and so this is a story that we did a little while ago called Revenge Porn or Revenge Whining. Right, that's what they call it. This is from December 2025, a few months back, and they were going and they're whining about how this is all revenge porn and everything else. And this is you can go to to my site.
Let's play the video. So
everybody play the Megan Fox video.
Yeah. So everybody knows what they call revenge porn.
I have to fuck her so she obeys me. I don't give a shit about having sex with beautiful women. I fuck them to me so I can get what I actually want, which is not them. It's a means to an end. Every single Bond girl was exploited. That's exactly what I do. When I watch a Bond film and I see him basically pimp a bitch, to me that speaks to my heart. I've been there. I've done that. Anyone who's followed me long enough knows that I've made my $1 million with a webcam business. I have met beautiful women, good personality, and thought, she will make me money. I have to fuck this bitch. I don't want to have sex with her. I just need the money.
Won't you take me to Funky Town? Won't you take me to Funky Town? Won't you take me to Funky Town?
What do you have in your mouth?
This is what they call revenge porn, sexual cyber stalking. This is what they are suing for.
This is what this lawsuit, this is what the federal court lawsuit is in a nutshell. That little video that we had that basically says there. And there we have, award-winning Megan Fox.
But then, Megan, how dare you say that Jeremy Hales files frivolous lawsuits? This is what he's filed for.
Yeah, and I have every right to do just, suggestive and stupid stuff. And I have a lot of suggestive and admittedly stupid stuff. But I'm allowed to do that. And so, and we'll get to this in a second. We'll read all this. This is them trying to defend it. And there's trashy Megan. But we have a situation here where we have the Larry Flynt. Actually, and let me actually go to that Larry Flynt thing. I think it's on the other page. Let me put it here. Yeah, here it is. Okay, I got it right here. I'm going to put this one on. Okay, this is the clip. This is the money clip.
A political cartoon that's over 200 years old. It depicts George Washington riding on a donkey, being led by a man, and the caption suggests that this man is leading an ass to Washington.
I can handle that. I think George can handle that. But that's a far cry from committing incest with your mother in an outhouse. I mean, there's no line between the two?
No, Justice Scalia. I would say there is no line between the two, because really what you're talking about is a matter of taste and not law. As you yourself said, I believe, in Pope versus Illinois, it's useless to argue about taste and even more useless to litigate it. And that is the case here. The jury has already determined for us that this is a matter of taste and not a matter of law, because they've said that there is no libelous speech, that nobody could reasonably believe that Hustler was actually suggesting that Jerry Falwell had sex with his mother.
So why did Hustler have him and his mother together?
Hustler puts him and his mother together in a example of literary travesty, if you will.
And what public purpose does this serve?
Well, it serves the same public purpose as having Gary Trudeau say that Reagan has no brain or that George Bush is a wimp. It lets us look at public figures a little bit differently. We have a long tradition in this country of satiric commentary. Now, if Jerry Falwell can sue when there has been no libelous speech purely on the grounds of emotional distress, then so can other public figures. And imagine, if you will, suits against people like Gary Trudeau and Johnny Carson for what he says on the Tonight Show tonight. Obviously, when people criticize public figures, they're going to experience emotional distress. We all know that. It's the easiest thing in the world to claim, and it's impossible to refute. And that's what makes it a meaningless standard. Really, all it does is allow us to punish unpopular speech. And this country is founded, at least in part, on the firm belief that unpopular speech is absolutely vital to the health of our nation.
Thank you, Mr. Isaacman.
So I think the most important thing is that, and Larry Flynt won that case. The argument that a public figure can't just claim emotional distress, because obviously being criticized is emotionally distressful, and yet that is what Jeremy Hales is claiming.
That's what, if you look there, that is exactly what is being said there, that he's claiming emotional stress. And I'm going to put up the other
For those
page.
who don't know this case, very famous case, and you saw Woody Harrelson there. He was playing Larry Flynt. The other guy was playing Jerry Falwell. He put in Hustler magazine a story in which Falwell was like acknowledging or confessing to bestiality, having sex with his mother. It was supposed to be absurd. He was making fun of him. He didn't like him, and they became friends later. But I think that Edward Norton's character, you just say that he didn't like the guy, and he wanted to mock him, and he has every right to mock him. And it went all the way to the Supreme Court, as you see, because they're arguing with Justice Scalia. Great line when you can quote the judge's own words back to him. And Flint won. And now satire is protected. And your video is no different. There is no one who watches that video thinks that's really Megan and Jeremy Hales. So in the same way that the law applied to Larry Flint, the law applies to you.
Yeah, so we're going to go right back to this article here, and this is what comes from. And I have to give props to John Grems when it's deserved. John Grems is a groupie really of Jeremy Hales, and he's got the Facebook site, and he puts me and you on like double super secret probation, before we could publish anything. But all the Hales people could publish whenever they want, and that's fine if he wants to. But he at least understands the nature of the First Amendment. And he actually defended the First Amendment. He didn't defend me because he doesn't really like me, but he defended the First Amendment. And that video we showed before was posted, and this is what was put on the page by Megan Fox. I'm going to read some of what she said. Megan Fox, author. Anyone on this thread should be reporting this post in this group for sharing revenge porn. I do not consent to my image being distributed in a gross sexual matter. Report for sharing unconsented sexual material and leave this group. Anyone who supports this kind of disgusting content should not be supported. Okay, and then I reply, Megan, revenge porn is distributing intimate photographs of their usually former partner without their consent. So you admit we did the nasty. Megan Fox, author. Richard Luthmann, the laws have changed, you idiot, and digital depictions are included in the laws, including federal. You are a scumbag. I do not consent to this harassing material. You're a piece of shit who deserves prison, and I'm sure you'll find your way back there soon. And then John Grems comes in there, and he tries to explain what the law is about revenge porn. It's a crime. It's about non-consensual images, right? And it's about something that you have an expectation of privacy in. And he gives a little explanation of it. And so then they talk a little bit about the group and everything else. And then Megan says, thank you for confirming you approve the sharing of revenge porn. You will be added to any legal complaint involving this. So Megan's like threatening to sue John Grems. And then John Grems makes my case for me. John Grems, Megan Fox author, where is the nudity? The sexual organs? When did you consent to the sexual act? This clearly is him making fun of you, like you're fat shaming and making fun of him. He's doing it to you. The problem is you can dish it out, but you can't take it. We'll see what the courts have to say about it. This isn't a threat. This is reality.
Right. And Jeremy just loves to sue. Loves
Megan Fox author. No, this isn't. It's depicting me in a sexual act. It is illegal and disgusting. It is nothing like saying someone is fat. He has taken my image and depicted me in a sexual act that is illegal under federal and state law. I've reported your page. I got Leslie's page deleted for the same thing. You want to try me? Keep it up. Otherwise, you should remove it immediately. Continuing to repost this harms me, my family, my reputation, and Jeremy Hales. I think you should have learned by now that harming Jeremy Hales maliciously leads directly to court. This is your warning. Take it down. And then John Grems. Megan, I'll refer you to Hustler Magazine v. Falwell, 1988 Supreme Court ruling. Flint also became a central figure in the 1988 Supreme Court case Hustler Magazine v. Falwell, where the court ruled that public figures cannot recover damage for emotional distress caused by parody, even if offensive, reinforcing protections for free speech under the First Amendment. His legal battles, including these trials, were instrumental in shaping the legal understanding of obscenity and free expression in the United States. I'm not hiding, just like Leslie when she threatened to sue me. Bring it on. His rights don't end where your feelings began. Freedom is scary. Deal with it. Megan Fox.
He's talking big, but he did remove, and it was a link to the video. But
John
he did
Graham,
remove it. Megan spent her career until 2024 talking about the First Amendment, how she defends it, until somebody makes a satire video making fun of her, and then suddenly it turns into revenge porn, and you should sue and go to jail for that. That's how much she cares about the First Amendment. Go ahead.
So John Graham's, there doesn't have to be nudity. There is depiction of a sexual act. That's enough. And a normal human being would not share something like this. Would you post this with your daughter's face on it or your mother's? You're a disgusting pig. Oh, and you're a lawyer now? You sound exactly like the freaks who made this. You're disgusting. Try me. John Graham's, there are no laws against fat jokes. There are laws against sexual acts. You approved it. You defended it. You will be defending yourself in court. Now, this is Jeremy Hales, right? There are no laws against fat jokes. You will be defending yourself in court. Now go cry victim as you made these life decisions. So he made life decisions. John Graham's, I'm no lawyer. I'm not about to be bullied anyone. Again, you can dish it out, but you can't take it. I'm a Jeremy supporter on the facts of the case and a free speech advocate. You are trying to silence someone else's legal speech. Jeremy Hales, no, you're about to be in a federal lawsuit. Still think it's funny breaking the law? John Graham's, Jeremy Hales, there is no law against making lewd or suggestive parody videos, criticizing the behavior of another. Is it offensive? Is it vile? Sure. But show me the law saying a cartoon is illegal. Then it says okay. Jeremy Hales, see you in court. Randy will be in contact soon. And then Graham says, like I said, show me the law and I'll remove it. And I said, revenge porn is threatening to share or sharing sexually explicit photos and videos of your partner or ex. So when we were together, Megan, we were together. Please tell everyone about it. Then Megan says, it is any sexual depiction with anyone, you asshole. I did not consent. That is my identifiable face, and it is depicted in a sexual situation. You are the scum of the earth, you fat fucker. And I have my nice little picture there of Jeremy Hales as a bitch and the pigsty behind me with the two pigs.
She really can dish it out, but she cannot take it. It's
that's the crazy part about this.
It's one of the features of this case. The Hales people will do a lot of stuff, but if that's done to them, they will run and cry. So, it's okay to talk about the private lives of somebody else, but if you talk about my private life, that's horrible. I can go film Michelle and John all I want, but if you show a photo of me, I'll sue. That kind of stuff comes up all the time with them. It's hypocrisy at its worst.
Like they're going to be ridiculous, and I'm going to show my motion now. But I kind of hope my motion doesn't get granted, so we can go to discovery and I can go to depositions and read this stuff back to them and make them comment on this on the record, because that will make them look totally ridiculous. Because if I don't get this motion granted and I'm not out of the case, I'm going to ask for discovery. I'm going to ask for videotape depositions. And the videotape depositions are going to be some of the greatest things you've ever seen in your life. Like, I will go, and I don't mind mine being, it's like, what's good for the goose is good for the gander. I don't mind mine deposition being taped, because I'm just going to run circles around Randy Shochet and Doreen Turner-Incolas, because they're morons. Randy's he's basically a dentist. He's a dentist that's being a hack lawyer for a guy who's too stupid to realize that his lawyer's a hack. Okay, so that's easy for me. Now, Jeremy's going to be on video. He's going to have to start answering these questions. And, it's not going to go like the Bruce deposition where he starts getting stupid. I'm going to just sit there like the old Chris Matthews days. Remember Chris Matthews on Hardball? And ask the question. When he doesn't give me a response, I'm going to ask the question again. I'll ask the same question 50 times. We'll get the magistrate judge on the phone. We might have to get it so we actually do the deposition in the actual courthouse. I have no problem going up to Gainesville and doing this in the courthouse with the judge right there ready to do a ruling. I will get a videotape deposition. I have no problem. So that's where we go.
All right. Let's get your response up.
Let's put it up here. All right, so this is the motion to dismiss, and this was filed in the court. And basically, the basis for this is 12B, and that's the motion. I talked about this the other day, how the judge kind of you know, when he denied my reconsideration last week or a couple weeks ago, he telegraphed that you could file a Rule 12 motion, and 12b-5, 12b-6, and 12b-1, right? That's going to talk about service. So the service stuff that Jeremy has in is all a waste of everybody's time. He's not going to get his McDonald's fast food motion for fees. The other thing is Rules 20 and 21. That's about severance. So I'm going to ask to quash purported substitute service and at a minimum sever the claims against him from the malicious prosecution claims against defendant Preston. So me and Michelle Preston have different claims. They happened at different times. There's no common nucleus operative fact.
Right.
No
Initially, they had a bunch of people who they claimed were in a conspiracy, and that's how they could put them all in. Now Michelle's got one thing. You got something completely separate. You're going to have two different lawsuits if the lawsuits even survive. Go ahead.
Yeah, so that's what I want. And I talk about the fee shifting and the protections of the anti-SLAPP statute. I invoke them there. And I raised all my other Rule 12 defenses, including my alternative dispute resolution, my trial by combat. But I asked some very simple relief. Dismiss count 2 with prejudice under Rule 12b-6. I want him to address the merits and say that this is not a claim, a stated claim under the revenge, the revenge porn statute. Quash the purported substitute service and dismiss under Rule 12b-5. That's service. So he never really served me. He didn't serve me because he lied to the court and Shochet lied to the court and Hales lied to the court saying
he's made 2 statements to the court that you can't square. When he tried to serve using the Secretary of State, he claimed that you were a resident of the state of New York.
And I was conducting business in Florida as a resident of New York, and I was hiding.
Right.
Those are 3 things.
Later,
resident of New York, conducting business in Florida, and hiding.
And now he claims you're a resident of Florida.
The amended complaint, he says I'm a resident of the state of Florida. So
right. So you have put into the court that he has made these 2 claims in order to fix whatever argument he had. He
clearly believed as early as like July or August when he served my father in Florida that I was potentially in Florida. Right. So, he knew a long time ago that I was someone in Florida. If he would do something, there's something called, let's wait for it, PACER. That is the electronic filing system that federal court lawyers use. If you type in Richard Luthmann's name, you'll find 6 or 7 cases in PACER very recently for 2021 on that I'm all in Florida with a Florida address in Collier County, Florida. So that's what these people have. They have the problem there with that. Now, I'll read a couple of these paragraphs because it puts this where it needs to be. This case did not arrive at the Third Amended Complaint, the TAC, by clean litigation. It got here by drift, retrofit, and procedural salvage. That's right. It's a procedural salvage because everybody else is partying. Robbie and Lisa and Marla, Ray Bone Crusher, Super Dave. Everybody's out. This case is out. I'm the salvaged portion that's left, me and Michelle. And Michelle would basically be out too if she wasn't in bankruptcy. Plaintiff first launched a sprawling, multi-defendant media war complaint, then amended again. Then watched the case narrow dramatically after dismissals, termination, service fights, defaults, a vacated default, and a belated pivot to a 2-defendant pleading. This is him trying to save face, and everybody knows it. What remains against Richard Luthmann is not the original anti-what-the-hell's media ecosystem, EPIC. It's a single statutory claim against Florida under Florida's sexual cyber harassment statute, stapled to an unrelated malicious prosecution claim against Lynette Preston. The old battleship has been stripped down to a dinghy, but plaintiff still wants the court to pretend the voyage was orderly. The service history tells the tale. Plaintiff named Richard Luthmann in the first amended complaint obtained a summons, failed to make a timely and valid service, chased addresses that did not match pleadings, pursued substitute service through Florida Secretary of State, and filed a third amended complaint admitting what the record has long shown. The intended defendant is Richard A. Luthmann Jr., a Naples, Collier County, Florida resident. That matters because plaintiff's substitute service theory depended on a different story. That Luthmann was a non-resident, was concealing his whereabouts, and could not be served despite diligent search and inquiry. Like you said, Michael, those 2 stories cannot coexist. The docket now presents the court with a simple threshold question before any merits circus begins. Was Mr. Luthmann ever properly brought before this court under Rule 4, or is plaintiff trying to turn failed service into jurisdiction by repetition? Defendant relies on the court's docket and requests the court take judicial notice of its own records. And I list the ECF numbers that prove the case. These are all Jeremy's filings. He's such a fool. Defendant cites those docket entries by ECF number in pinpoint page or paragraph. Does not ask the court to comb the docket. The cited filings are identified because they bear directly on service, jurisdiction, pleading history, Rule 4M, and the operative Third Amended Complaint. The operative pleading is the Third Amended Complaint. It's far narrower than the prior pleadings. The First Amendment complaint and the second complaint allege a broader online business and media ecosystem theory, expressly alleging Hales generated revenue through YouTube, Facebook, TikTok, monthly subscriptions, and whatnot auctions, and expressly alleged that Luthmann was domiciled in Staten Island, Richmond County, New York. This complaint, by contrast, now alleges only two claims, one against Preston, one against Luthmann, and now alleges Luthmann is a resident of Naples, Collier County, Florida. As to Luthmann, the third complaint alleges two emails from January 2025 and an online video. It alleges Luthmann sent an email to the Anti-Defamation League, sent an email to a YouTube channel called That Umbrella Guy, and posted a video depicting plaintiff as Adolf Hitler by adding a Hitler mustache to plaintiff's photograph and engaged in oral sex with a journalist. I'm not sure who that journalist is. Maybe it's Don Lemon. Based on these allegations, plaintiff brings count 2 under Florida statute 784.49 and seeks injunctive relief, fees, statutory damages, the amount of $375,000 or $5,000, whichever is greater. I don't know how Shochet could write that with a straight face. $375,000 or $5,000, whichever is greater. How do you write that? That's like the most retarded sentence I've ever heard. I'm gonna go get a 5-year-old in here. $375,000 or $5,000. Which one's greater? Which one do you want?
Right.
Friggin' moron. Service record is equally important. October 30th, 2025, the court expressly refused to deem Luthmann served. On August 4th, 2024, refused to authorize email service and refused to direct entry of default. So Judge Bolitho said, and it's the law of the case, you cannot serve Luthmann by email. Shochet asked for it. November 24th, plaintiff moved for more time to serve Luthmann and represented that substitute service was being pursued because Luthmann was a non-resident and concealing his whereabouts. It's right there, number 142, paragraph 6 to 10. He purges himself. November 25th, the court granted more time specifically because plaintiff said he needed additional time to complete the substitute service requirements under the statute. The only reason he got the more time is because of what Shochet and what Hales said to the court. The lie that was the fraud on the court. December 29th, the plaintiff filed return of substitute service and process, again swearing that Luthmann was a non-resident and was concealing his whereabouts and had not been personally served despite diligent search. The exhibits of the filing reflect attempted service at multiple different addresses in Naples and Staten Island, inconsistent address information, and an August 17th email in which Luthmann expressly rejected email service and demanded strict compliance with Rule 4. Right? I'm allowed to do that. I want Rule 4 requirements. He didn't send me the package that he wanted to. He couldn't send it to me. And email service isn't good enough. He didn't nail it to the right address. April 8th, the court set aside the clerk's default against Luthmann. April 27th, 2026, the court held the early motion to dismiss and strike moot because the Second Amendment complaint had superseded by the Third Amendment complaint. Plaintiff's handling of this case, Jeremy Hales handling this case, bears the marks of polymop, protraction of litigation and multiplication of proceedings, not ordinary merits litigation. The pattern is visible on the docket. Plaintiff first filed a sprawling First Amendment complaint naming Richard Luthmann and obtaining a summons May 1st, 2025, starting the Rule 4 service clock, but then cycled through defective service efforts, an extension request, substitute service filings, a default, a vacated default, and finally a narrower Third Amendment complaint that now admits Richard A. Luthmann Jr. is a Naples, Florida resident. Plaintiff's substitute service theory depended on the sworn assertion that Luthmann was a non-resident. Concealing his whereabouts could not be served despite diligent efforts and inquiry. Yet the operative pleading now relies on the opposite proposition, Florida residency, to establish personal jurisdiction. This is not clean litigation. It is narrative repair for his YouTube audience after procedural failure. Plaintiff then sought expedited collateral relief over service costs while the service and jurisdiction defects remain unresolved, even though the court had already set aside the clerk's default and left dismissal issues for later. This sequence supports the inference that litigation is being used not merely to resolve a legal dispute, but to keep generating docket events, pressure, cost, reaction, and most importantly, content. How do you feel about that, Michael?
You're saying the same thing I am, that they say is ridiculous. The same people who cover every single motion and other filing say it's ridiculous to say that these things are only being filed for YouTube content.
Yes. So Rule 11 prohibits filings presented for improper purpose, including harassment, necessary delay, needlessly causing litigation costs. Section 1927 likewise authorized sanctions against counsel who multiplies the proceedings in any case unreasonably or vexatiously. Multiplies the proceedings. That's in Palamop.
Right.
Multiplication of proceedings. We have 11th Circuit cases. 11th Circuit, which is the Federal Appeals Court, they look at that too. Here, after multiple notices and multiple opportunities to cure, plaintiff did not simplify, correct, and serve properly. He escalated. That is Palamop in practice. Lawsuit as machine, docket as stage, and federal procedure as fuel. And so that's this whole thing in a nutshell. Okay, and I don't have to get into the stuff we talked about.
Show your argument against the cyber stalking. You made the argument against the defective service.
Yeah, the defects we talked about. The cyber stalking we just talked about. This is here we go. Let's see. Count 2 fails to state a claim. Count 2 also fails in the face of the pleadings. Florida's sexual cyber harassment statute is not a free-floating civility code for ugly internet speech. By text, it targets publication of a sexually explicit image. I still haven't seen one yet. That contains or conveys the depicted person's identifying information, published out without consent, contrary to the depicted person's reasonable expectation that the image would remain private. Those were public images that were used in the cartoon for no legitimate purpose and with intent to cause substantial emotional distress. Okay, the statute's legislative findings reinforce the point. The statute is aimed at publication of genuinely intimate material, an image taken with the person's consent that nonetheless retains a reasonable expectation of privacy. There was never any reasonable expectation of privacy in the quote-unquote images that were used in the collage, the satirical collage. The civil remedy is very specific. Injunctive relief, attorney's fees and costs, and $10,000 or actual damages incurred as a result of the violation, whichever is greater. So the $5,000 that he asked for is actually even wrong. When he said $370,000 or $5,000, whichever is greater, it's really $10,000 the statutory amount. So he's a moron. The Third Amendment case does not plead that kind of case. Its own allegations describe a manipulated or composite publication, a video depicting plaintiff as Adolf Hitler by adding a Hitler mustache to plaintiff's photograph and engaging in oral sex with a journalist, Don Lemon. That is the Third Amendment's complaint's description, not defendant's spin. Plaintiff's own telling the challenge publication is a vulgar edit or montage built from plaintiff's photograph, but not an actual private nude image or actual private sexual recording of plaintiff. I didn't record Jeremy Hales. That was actually Andrew Tate. It's not a private recording. It's a public recording of Andrew Tate that I released on the internet. It's in the public domain. Fair use because I made it into satire. Jeremy's picture all over the internet. Megan's picture all over the internet. Third Amendment complaint nowhere alleges the plaintiff ever created a real sexually explicit image of himself, ever shared one with defendant, or ever had some image that would, quote, remain private within the meaning of the statute. What in that it deserves privacy? Nothing. That missing privacy history element is fatal. A public headshot does not become a statutorily private sexual image merely because someone later uses it in an offensive edited publication. Nor does the third complaint plausibly plead the privacy element in any non-conclusory way. 87 through 99 are entirely formulaic recitations. No consent, no legitimate purpose, not newsworthy, intent to distress, and so on. Under Twombly and Iqbal, the two important cases in drafting, that doesn't suffice. Okay, Ashcroft v. Iqbal, Atlantic versus Twombly. Third complaint offers no non-conclusory factual allegation that the alleged depicted sexual material was an actual private image of plaintiff rather than an edited representation using a photograph. And if the statute was stretched to cover parody, satire, or grotesque image manipulation built from public photographs, untethered to any private intimate image, grave First Amendment concerns would follow. Tell me what any actual private intimate image we're talking about. They can't. This court should not adopt that expansive reading. Hustler Magazine versus Falwell. The damages demand confirms the pleading defect. The Third Amendment claims for $300,000 or $5,000, whichever is greater. The statute does not authorize $5,000 or more. It authorizes $10,000 or actual damages, whichever is greater. The prayer is therefore not justified. Is not just inflated. It's not textually misaligned with the statute it invokes. Plaintiff's allegations of embarrassment, fear, lost opportunity, strain of relationships, expense, and inconvenience are too conclusory and too unquantified to plausibly transform the statute into a $370,000 claim. And I talked here about the issue of the $75,000. That we have that issue about subject matter jurisdiction. I don't think we're going to get there. I preserved that right here. I raised it and I preserved it. I don't think it's going to get there. And then I said, if the court doesn't dismiss, I'm misjoined. So sever me from Lynette Preston, from Michelle Preston, because we have two different cases, different actors, different acts, different dates, different proof, different remedies, different legal elements, different defenses. Then the Florida SLAPP statute. We asked about the Florida SLAPP to protect me there. I have my alternative defense resolution. My trial by combat, pro se solicitude. This is the stuff we talked about before about learned in the law and about Minnesota. Okay, and it talks about how the Judge Weinstein found that I am not learned in the law, and my prior legal experience doesn't overcome my craziness. Okay, and then here's the cool one, right here. Request for oral argument. I respectfully request oral argument. The issues refer to Rule 12. The scope of the Florida statute, the severance question, 30 minutes per slide. I want to go to Gainesville and I want to argue this. I might as well get dressed up for this stuff. Might as well be fun, and I get dressed up. And here's me, and here's all the stuff here, and here's everything I ask. And then here's me signing all this other fun stuff. Here's the envelope. So they did it all really well. That is what we have, Michael. That's our motion right there.
All right. And the reason you didn't address your emails to the ADL and your email to TUG is because they don't fall under the statute for sexual whatever it is, sexual cyber stalking. So you didn't need to address those. Am I right?
That's right.
Okay.
Oh, come on. It's saying that we're not afraid. That's right. We are not afraid. And this is true. They treat Jeremy Hales as a joke. And this is true. They should have to pay your father for dragging your father into this. He could still sue. He hasn't got a year to sue. So I think he has until August or so to sue them under an intentional tort theory, which he may very well do. And yeah, I think that Andy has it right. I might be doing the full out Larry Flint if we go to Gainesville. I'm gonna have a Larry Flint moment. I'll have a camera crew with me. I might even come in, ready to go in my American flag diaper. Who knows what we're gonna do? But
you're gonna pull like Afro Man.
I might do an Afro Man. That's right. Lemon pound cake. Lemon pound cake for everybody at the Gainesville Federal Courthouse.
We've been on for way too long. Let's end.
We're on almost for 2 hours today. Did everybody like this show? That's what you let me know in the comments section. If you like the show,
if you like the show, maybe we'll do it every Thursday.
Helen, we did. I'm not saying I said diaper as a joke. I'm not going to wear a diaper, but Larry Flint actually wore a diaper in the federal district court in the Larry Flint case. He said if they're going to shit on the Constitution, he might as well do it too. And so that's what he did. And so thank you, John. I think we did a good show today. I'm going to leave with the outtake that we have because I got to go because it's late. But the outro that we're going to do is the one we came in with. And that's the one about Germ, and Germ has been left.
And we're going to leave. Two last points I want to make. Larry Flint is
I'm going to show some pictures. Well, I'm going to show some pictures while you make the points. I'm going to show some pictures.
Larry Flint is a First Amendment hero. And after the events depicted in that movie, he and Falwell became friends, genuine friends. I think that's very important. And that part of the story is rarely told.
Right. Keep talking. I got some more pictures.
All right. No, that's all I got. And if you guys like this one, maybe we'll be back next Thursday.
Yeah, there's our favorite friend, your former friend. That's her. That's how she looks without her makeup. That's what I heard, at least. And then I showed this one before. Melonhead Megan, right? And then this is our thing for today. And so what I will do is I will sign off. Everyone have a good day and enjoy the outro video.
I love what paint chips can do inside and outside the kitchen with an oversized mushroom.
George packed her bags by the light of the moon. be leaving real soon. He cried by the courthouse, yelling at the sky, but George just waved and said goodbye. Oh, George left Germ, yeah, she hit the road. No more drama, no more overload. He's got violence, she's got freedom tonight. George left Germ and she's feeling alright. Surf guitar, George left Germ. Goodbye.